I'm Dru Stevenson, and this is a lecture about the case Hoctor versus the Department of Agriculture, a 1996 decision from the Seventh Circuit Court of Appeals. And our issue here is about interpretive rules versus legislative rules under the Administrative Procedure Act. So let's take a look and see what we're doing in the case. This is a case for my Statutory Interpretation and Regulation class, and it's also a note case in my the casebook that I use for my administrative law course. So students from both administrative law and statutory interpretation, or Leg-Reg, would find this useful. So our main takeaway in this case, or the critical question, is what counts as a regulation or rule that has to go through APA notice and comment rulemaking procedures. And just to review, those procedures mean that the agency publishes a detailed proposed rule invoking the relevant statute and explaining what they're planning to do and how and why in the Federal Register, and they allow a public comment period, and then at the end of the public comment period, they promulgate a proposed or a final rule that actually goes into effect. And those regulations will have the force of law, the same as a statute. Now, the agency here is the United States Department of Agriculture, or USDA, and they characterize their guidance document here as an interpretive rule to basically, and by doing such, avoided the process of going through notice and comment rulemaking. Notice and comment rulemaking takes a long time. It's labor intensive. It can trigger political backlash and things like that. So agencies could have an incentive to save all those steps and just issue a guidance document to the regulated industry about how they're interpreting ambiguous provisions in a statute or regulation. So here at our act or statute is the Federal Animal Welfare Act, and it authorizes, it's our enabling statute here, the Secretary of Agriculture to promulgate regulations and rules governing the handling and housing of exotic animals such as tigers and lions. And so if you watched the miniseries on Netflix called The Tiger King, that we're talking about someone like that, like Joe Exotic, who has a compound and raises tigers and lions and ligons and so forth. And so the secretary had promulgated a regulation and had followed APA notice and comment rulemaking under Section 553, providing that, quote, the facility that's housing the animals must be constructed of such material and of such strength as appropriate for the animals involved, and that facilities must be sufficient to protect the animals from injury and to contain the animals and keep them basically from escaping. So there's no question about this regulation that the agency promulgated, whether it's valid. They followed the APA's notice and comment rulemaking procedures just like they were supposed to. But the problem is, what counts as sufficient? So then the USDA issued a guidance document that it called an interpretive rule. And this document provided that in the case of dangerous animals, including big cats like lions and tigers, the facility must be surrounded by a perimeter fence that's at least 8 feet high. So now let's talk about Mr. Hoctor. Hoctor was an exotic animal dealer, and he raised lions and tigers and ligers and cougars and so forth. But his perimeter fence was only 6 feet high. And so the department then fined Hoctor for failing to have a high enough fence. Hoctor objected on the grounds that the 8-foot fence requirement was an invalid regulation or legislative rule. He said that a height requirement should have gone through notice and comment procedures, and so therefore the agency had no basis for fining him. Arguably here, the USDA was treating the 8-foot fence rule as if it had the force of law. The agency basically penalized him solely because his fence was 6 feet, not 8 feet. And remember, the regulation just said it had to be high enough or sufficient, adequate to contain the animals and keep them from escaping. And the agency had decided that their rule of thumb was that that meant 8 feet. So the department claimed that the legal basis for its enforcement action against Hoctor was actually the original regulation, which did follow notice and comment rulemaking, providing that housing must be appropriately strong and sufficient to prevent the animals from escaping. In other words, they're saying, look, the fact that we interpret this as 8 feet is not why you're being penalized. We interpret this, and this is the basis for your fine or your penalty. In other words, the department says the interpretive rule merely provides clarification on how the agency interprets its own regulation, and the regulation is valid and is not what Hoctor is challenging in his suit. So arguably, this provides more notice, this is the agency talking, to those who raise or keep big cats, because it avoids surprise when the department fines them for having a short fence. In other words, if they had just not put out a guidance document and had shown up and said, we don't think your fence is high enough to contain the animals, that probably would have been valid, or he wouldn't have really had a basis for the challenge. But then it would create all this uncertainty, and you would never know if your fence was going to be high enough when the site inspectors actually showed up. So in this case, the agency had drawn what Judge Posner, that's who writes the majority opinion for the Seventh Circuit, described as an arbitrary line, not just in the sense that it was unjustifiable, but in the sense that it might have been equally plausible to have a 7.5 foot or a 9 foot requirement. This illustrates something kind of interesting about rules, that sometimes we have to have a rule. Like if you think about your dealing with your registrar's office for registering for classes or your drop ad period, they have to set a date. And it's not like that date is magical or is, the day the country was founded or something like that. It's a date that they had to pick a due date so that they could process things and have finality. And so the date is picked arbitrarily, and then ironically, our most arbitrary rules, we end up having to enforce the most rigidly a lot of times in our legal system. Or to give another example that's very familiar from everyday life, speed limits. So it may be on the particular stretch of road you were on for that mile that technically the optimally safe speed would have been, let's say, 66.3 miles per hour. But we're not going to have these endlessly varying speed limit signs that go out to the second or third decimal point. We're just going to kind of round it off, and we have to pick a number for how safe we want to, how fast we want people to drive. And so this is a somewhat arbitrarily picked number. Deadlines, dates, heights, widths, mandatory things like that. Often an agency just they have to pick something so that they can have a number, and then that's everybody knows is good enough, and then they can enforce that. And the problem is then they enforce it rather rigidly. So I pulled out several quotes from this case. Posner's a beautiful writer, and he explains this situation here very clearly. When agencies base rules on arbitrary choices, they are legislating, he says. So these rules are legislative or substantive and require notice and comment rulemaking, a procedure that is analogous to the procedure employed by legislatures in enabling statutes. Distinguishing between a legislative rule, to which that's what he's calling like a regulation that has a force of law, to which the notice and comment provisions of the APA apply, and an interpretive rule to which these provisions do not apply, is often very difficult. Just a second. And often very important to the regulated firms and the public and to the agency. Notice and comment rulemaking is time consuming. He concedes that. And it facilitates the marshaling of opposition to a proposed rule. So this was talking about the political backlash or a concerted effort by the industry to prevent a rule from going into effect. And it may result in the creation of a very long record that may in turn provide a basis for a judicial challenge to the rule if the agency decides to promulgate it. In other words, you create when you go through notice and comment rulemaking, you create a long paper trail or record. And so there's a lot more things that someone later on could seize on to say this rule is invalid. and it should be done over again. So he says there are no formalities attendant on the promulgation of an interpretive rule, but this is tolerable because usually these rules are just an interpretation. They don't have the force of law. Now, he kind of says near the end of his opinion, if the department had said, let's say in an internal memo to its employees, that it could not imagine a case in which a perimeter fence for dangerous animals that was lower than 8 feet would provide a secure containment, and that it would presume that lower fences were insecure, it actually might have won this case, right? But instead they put out this guidance document just saying once and for all that if your fence was lower than 8 feet, that they were going to fine you. And instead of really using it as a rule of thumb and then allowing some leeway for case-by-case situations, they had put out something that in practice was functioning like a regulation and had the force of law. So in conclusion, Posner says, in that case, if the agency had just used an internal memo saying that they just can't imagine that less than 8 feet is enough to their own staff, it would have been tethered to the original regulation more closely, which was about secure containment rather than making it a freestanding rule, as Posner calls it. And in this case, however, the order was vacated and Hoctor won. That concludes our lecture about Hoctor versus the Department of Agriculture.